The house had always been quiet, the kind of quiet that felt earned after a lifetime of hard work. It sat in a neatly planned suburban neighborhood governed by an HOA that loved rules more than people. Perfect lawns, identical mailboxes, and streets that looked staged rather than lived in. For years, that sameness had never been a problem. Until life changed in a way no rulebook could prevent. The change came suddenly. A medical emergency left my father permanently disabled, confined to a wheelchair almost overnight. A man who once fixed his own roof, washed his car every Sunday, and waved to neighbors from the driveway was now struggling with the basic act of entering his own home. The front steps, once meaningless, became a daily barrier. Each trip outside required lifting, strain, and risk. It was unsustainable, unsafe, and cruel. So we did what any reasonable family would do. We built a wheelchair ramp. It wasn't flashy. It wasn't oversized. It followed medical guidelines, matched the house color, and was tucked along the side of the front yard, partially shielded by bushes. From the street, it was barely noticeable. It didn't block sidewalks, didn't extend into common property, and didn't reduce anyone's precious curb appeal. It simply allowed a disabled man to live with dignity. For the first few days, everything seemed fine. Neighbors watched quietly. Some avoided eye contact. Others offered polite smiles that didn't quite reach their eyes. No one said anything directly. The silence felt uneasy, but we assumed compassion still existed somewhere beneath the manicured hedges. Then the letter arrived. The HOA envelope was thin, official, and cold. Inside was a violation notice citing unauthorized exterior modification. The ramp, according to the HOA, violated aesthetic guidelines. The solution wasn't to submit paperwork retroactively or request a variance. The solution, apparently, was immediate compliance or fines. The fine amount was staggering. $200 per day. Not a one-time penalty. Not a warning. A daily punishment for daring to make a home accessible to a disabled resident. The language in the notice was mechanical, stripped of humanity. It spoke of uniformity, precedent, and enforcement consistency. There was no mention of disability laws, no acknowledgement of medical necessity. Just deadlines and consequences. At first, we assumed it was a mistake. Surely, once the HOA realized this ramp existed for a disabled homeowner, common sense would prevail. We gathered medical documentation, photos, and measurements. We prepared to explain, calmly and respectfully, that this wasn't an aesthetic choice but a necessity. The response came quickly, and it crushed that optimism. The HOA doubled down. They acknowledged my father's condition but claimed it was not their responsibility. They suggested alternatives that bordered on absurd, including using the garage entrance exclusively or finding a way to make the ramp less visible from the street. One line stood out, chilling in its implication: the ramp created an unpleasant visual impact. The fines began accruing immediately. $200 per day became a ticking clock. Every sunrise meant more debt, more pressure, and more stress placed on a man already dealing with loss of mobility and independence. The ramp that gave him freedom now came with a financial noose. What hurt most wasn't the money. It was the message. The HOA wasn't just enforcing rules. It was sending a clear signal that disability was an inconvenience, something to be hidden away, disguised, or quietly managed behind closed doors. The neighborhood's image mattered more than a human being's ability to leave his home safely. Neighbors began to notice. Some whispered. Some stared. A few avoided the house entirely, as if disability itself were contagious. No one openly challenged the HOA. No one offered support publicly. The silence grew louder with each passing day. The fines continued to stack up. Attempts to reason with the HOA board went nowhere. Emails were answered with copy-pasted sections of bylaws. Requests for meetings were delayed. Every response carried the same tone: impersonal, dismissive, final. The rules were the rules, and exceptions set dangerous precedents. Meanwhile, my father watched all of this from his wheelchair. He saw the letters. He saw the stress. He saw the numbers climbing. And slowly, painfully, he began to internalize the blame. He suggested removing the ramp. He suggested staying inside more. He suggested becoming invisible. That was the moment everything changed. Because this was no longer just about a ramp. It wasn't even about money. It was about dignity, legality, and a system that relied on people not fighting back. The HOA assumed we would fold, comply, and quietly accept the injustice. They were wrong. What they didn't know was that their carefully worded violation notice had triggered something far more dangerous than a compliance request. It had triggered a deep dive into laws they had ignored for years. Federal protections they hoped homeowners wouldn't understand. Legal obligations they had quietly violated in the name of aesthetics. The ramp remained. The fines continued. And behind the scenes, a strategy began to form, one rooted not in emotion, but in the very legal system the HOA claimed to respect. The war had officially begun. The HOA believed time was on its side. Every passing day added another $200 to the total, another layer of pressure meant to force surrender. Their strategy was simple and familiar: overwhelm homeowners financially until compliance felt cheaper than resistance. It had worked countless times before. Most people folded quietly, removed whatever offended the board's sense of order, and moved on. But this situation wasn't ordinary, and their confidence was dangerously misplaced. Behind closed doors, while the fines quietly accumulated, something far more powerful than frustration was taking shape. Research replaced panic. Documentation replaced emotion. The very bylaws the HOA worshipped became secondary to a much larger legal framework they had failed to consider. Disability protections were not suggestions. They were law. Federal housing regulations existed specifically to prevent this kind of discrimination, and they were far more enforceable than any neighborhood covenant. The Fair Housing Act did not care about uniform mailboxes or visual harmony. It cared about reasonable accommodations. It cared about access. It cared about whether a disabled person could live safely and independently in their own home. And the ramp qualified on every level. The more the research deepened, the clearer the picture became. HOAs were not exempt from federal law. They could regulate paint colors and lawn height, but they could not penalize medically necessary accessibility modifications. Fining a homeowner for a wheelchair ramp wasn't just morally questionable. It was legally reckless. Even worse for the HOA, their written communications were airtight evidence. Every violation notice, every dismissive email, every line referencing aesthetics over accessibility formed a paper trail that clearly showed intent. Not ignorance. Not confusion. Intent. They knew my father was disabled. They knew the ramp was necessary. And they fined him anyway. Meanwhile, the HOA continued acting as if none of this mattered. Another letter arrived, colder than the last. The total fine amount was now listed in bold, accompanied by a warning about potential liens if payment was not made. The implication was clear: comply or risk losing the house. It was a threat designed to terrify, especially someone already vulnerable. But fear had begun to fade, replaced by something steadier. Preparation. A formal response was drafted. Not emotional. Not angry. Precise. It cited federal statutes, previous legal precedents, and specific sections of disability law. It outlined how the ramp met every standard of reasonable accommodation. It explained, in unmistakable terms, that continuing to fine a disabled homeowner exposed the HOA to significant legal liability. The letter didn't ask for permission. It informed them. The ramp would remain. The fines were unlawful. Any further enforcement would be documented. The HOA's reaction was silence. Days passed without a response. The fines, however, did not stop. Automated notices continued as if no warning had been issued at all. This silence wasn't accidental. It was a calculated gamble. The HOA was hoping intimidation would outlast resolve. At the same time, the situation inside the house was changing. My father had stopped suggesting removal of the ramp. The shame that had crept into his posture began to lift, replaced by quiet determination. He used the ramp daily, reclaiming pieces of independence that had been slipping away. Each time he rolled outside, it was an act of resistance against a system that wanted him hidden. Neighbors began to notice more than just the ramp. They noticed official-looking envelopes. They noticed tension. They noticed that something bigger was happening. Quiet conversations started forming at mailboxes and driveways. A few homeowners, long frustrated by the HOA's heavy-handedness, began paying attention. Because this wasn't just about disability anymore. It was about power. The HOA had grown comfortable enforcing rules without challenge. Over time, their authority had expanded unchecked, relying on fear rather than fairness. The ramp issue had exposed a weakness they never expected to face, a rule they couldn't legally enforce. Still, the board refused to back down. Instead, they escalated. A notice of formal hearing was issued, demanding attendance to address ongoing violations. The wording was intimidating, filled with references to penalties and enforcement measures. It was meant to reassert control, to remind everyone who held authority. But the balance had already shifted. Everything was documented. Every fine. Every notice. Every delay. The hearing date wasn't a threat anymore. It was an opportunity. Preparation intensified. Additional legal resources were consulted. Complaints were drafted but not yet filed, waiting for the right moment. Agencies responsible for enforcing disability protections were identified. The strategy was no longer defensive. It was surgical. The HOA still believed they were dealing with a stubborn homeowner. They had no idea they were building a case against themselves. The hearing approached, and with it came subtle changes in behavior. Emails became less aggressive. Language softened slightly. The fines were still listed, but explanations grew vague. It was the first sign of doubt creeping into their confidence. Too late. Because once disability discrimination is documented, it cannot be undone by politeness. The damage had already been done. The violations were real. The exposure was massive. The ramp stood untouched. The fines continued to grow. And the HOA, still clinging to its authority, walked steadily toward a legal reckoning it had created with its own rules, letters, and arrogance. By the time the scheduled HOA hearing arrived, the situation had grown far beyond a dispute over a wheelchair ramp. What had started as a violation notice had transformed into a documented pattern of discrimination, intimidation, and unlawful enforcement. The HOA still believed it could control the outcome by following procedure, but procedure alone could not erase what had already been committed to paper. Every fine notice, every dismissive response, every delay was organized into a timeline that told a clear story. It showed how quickly the HOA had chosen punishment over accommodation, aesthetics over accessibility, and authority over law. The narrative was no longer emotional or subjective. It was factual, chronological, and devastating. The hearing itself became a turning point. The HOA board attempted to frame the issue as a neutral enforcement matter, but that framing collapsed under the weight of federal protections they could not override. Disability accommodations were not optional. They were mandatory. The ramp met the legal definition of reasonable accommodation, and the HOA's continued fines constituted active discrimination. For the first time, the board members appeared uncertain. Their confidence wavered as the legal exposure became impossible to ignore. Questions about precedent were replaced with concerns about liability. The authority they had relied on for years suddenly felt fragile when measured against federal enforcement mechanisms. Within days of the hearing, the tone shifted dramatically. A formal notice arrived reversing the violations. The fines, once listed with bold authority, were quietly erased. The total balance was reduced to zero. No apology was offered, but the silence itself spoke volumes. The HOA was retreating. But the damage had already extended beyond fines. The documented violations were submitted to the appropriate housing authorities. The evidence was thorough and undeniable. Investigations began, not just into the ramp incident, but into the HOA's broader enforcement practices. Patterns emerged. Other homeowners came forward with stories of selective enforcement, intimidation, and disregard for legal protections. The ramp case had opened the door. What followed was a reckoning. The HOA faced formal findings that confirmed discrimination against a disabled resident. Penalties were assessed. Mandatory policy changes were ordered. Board members were required to undergo fair housing and disability compliance training. Oversight was imposed where autonomy once existed. Financial consequences followed. Legal fees mounted. Insurance premiums increased. The cost of defending indefensible actions far exceeded the fines they had once demanded. The board's reputation within the community suffered irreversible damage. Trust evaporated. Eventually, leadership changed. Board members resigned or were voted out, replaced by individuals forced to rebuild credibility from the ground up. The rules were rewritten to explicitly protect accessibility accommodations. What had once been treated as an eyesore was now formally recognized as a right. And through it all, the ramp remained. Not hidden. Not altered. Not removed. It stood as a permanent fixture, both functional and symbolic. A quiet reminder that dignity could not be fined away, and that power without accountability eventually collapses under its own weight. My father used the ramp freely, without fear of letters or penalties. The hesitation that once followed every trip outside disappeared. His world expanded again, not because the HOA allowed it, but because the law demanded it. The neighborhood changed too. Residents became more aware, more willing to question authority, more prepared to push back when rules crossed into abuse. The ramp had sparked conversations about fairness, compassion, and the limits of control. The HOA never admitted wrongdoing. They didn't need to. The erased fines, the enforced reforms, and the public consequences spoke louder than any apology ever could. Their attempt to assert dominance had ended in exposure, accountability, and lasting change. What began as a $200 per day fine ended as a lesson written into policy, law, and memory. The HOA tried to hide disability. Instead, they exposed themselves.